Just a very quick comment on elected officials as negotiators. Most council members aren't going to find yourself in this situation because you are not with that authority as a council member, but I do caution you that you may think that you are a good negotiator because, frankly, look what you were able to do in achieving your election to office. But the ability to negotiate successfully for the city may not be necessarily shown by your ability to get elected, so be careful out there. Laws provide for your forfeiture of office in certain situations. It's rare, but it can happen. Here's a photo of former New York Governor Eliot Spitzer. If you are convicted of a felony or a crime or misdemeanor involving moral turpitude, under the laws of Washington, you may no longer serve as a municipal officer. You essentially forfeit your position. He resigned, of course, or he would have forfeited his office had he been convicted of the prostitution crimes. You also, in cities, can forfeit your office if you have a number of unexcused serial absences from council meetings. It's unlikely any of you will find yourself in that situation. Resignation. You can also lose office as a result of resignation. Be careful about what you say at this council meeting. Just so happened in the city of Paulsbo a few years ago, council member in a huff stood up and said, "I'm done with you, I'm out of here, I resign," slammed her books down and left the council chamber. The next week, prior to the next council meeting, she wrote to the council, said, "I've withdrawn my resignation, you haven't accepted my resignation, and therefore I'm still a council member." In this particular court case, State Ex Rel Monroe versus City of Paulsbo, the court in 2002 ruled in favor of the city and said as soon as she said she's resigned, she was out. You can't rescind that resignation statement after it's made. So be sure that you don't let the moving truck get there too soon, and hold your temper. Laws of Washington, and again, we keep coming back to this notion of ethics and the progressive era in which we became a state and has really infused our activities at the local and state level throughout, prohibits the holding of incompatible public offices, or sometimes called dual office holding. I'm not going to talk a lot about this today, but it's in the MRSC publication, Knowing the Territory, that we talked about, discussed more extensively at pages 12 and 13 of that material. But to give you an example of how an office could be incompatible, technically, you as a council member could not also serve as a volunteer firefighter in your community. Why? Because a firefighter is a position of an officer in your city. Police are not the only officers. There are a number of others who hold that designation as a matter of law. A firefighter is an officer. There is a specific state statute that authorizes a council member to also be a volunteer firefighter. Without that statute, you could not serve in both capacities. Another example of that might be a mayor serving as a port commissioner. And in the port district that happened to include that city, the Attorney General's office found that that was an incompatible public office, and you could hold one but not both of those seats. Got a question that came in from one of the areas about a council member serving as a fire district commissioner. If the city is not annexed to that fire district and it's a contract service, then the city council member may very well have an incompatible public office as a result of his service as a fire commissioner and a city council member. I would encourage that particular council member to visit with the city attorney or to call MRSC to address that more fully. We talked about forfeiture of office. We talked about resignation. We also should talk very quickly about recall. Many of you remember not too long ago when the California Governor, Gray Davis, having been elected only for a couple of years, was recalled by the people of the state of California, and Governor Arnold Schwarzenegger was elected in his place following Governor Davis's recall. In that situation, under the California structure of law, that was basically the people saying, we just don't like you, Gray Davis, anymore. We don't want you to be our governor. That authority for recall does not exist in the state of Washington. The state recognizes that it is very difficult to do what you do. And the state imposes all sorts of restrictions on the manner in which you do business. And that you will make difficult decisions and often unpopular decisions in your communities. That does not allow for recall. In Washington, recall must meet two tests: factual sufficiency and legal sufficiency. The factual sufficiency must be shown by verified petition under oath. That is, that somebody who claims that you have done something has to swear under oath that they have personal knowledge of that activity. I saw council member so-and-so taking $500 from a contractor in return for his vote on a public works contract. Or I observed these four council members meeting and talking about city government outside of an open public meeting. Sworn before me this blank day of blank, just as you would do in any formal document. You need that formal, personal attestation of wrongdoing. The wrongdoing can be any violation of the oath of office or criminal law, but it must be verified. Then the question is it a violation of the law? Misfeasance, malfeasance, or a violation of the oath of office. And in that situation, then, you take that petition to court, because it always goes to court first, and the court will decide whether or not the petition is valid before you ever circulate it for signature. Once the court determines it's valid, then the Supreme Court has direct review immediately of the trial court's ruling. And once the Supreme Court has ruled, then the matter can go forward to the vote, or for petition signature gathering, recall, signature gathering, and then election on the question of recall. And so in situations here, exercise of judgment or discretion cannot be grounds for recall in the state of Washington.